I'm calling to order this hearing. This is a public hearing of the Committee of the Whole of the Council of the District of Columbia. I'm Phil Mendelson, Chair of the Council and Chair of the Committee of the Whole. Today is Wednesday, March 26, 2025. The time is 10:02 in the morning, and this hearing is being held in room 412 of the John A. Wilson Building. The subject of this hearing is Bill 26-48, entitled Review of Agency Action Clarification Amendment Act of 2025. This bill was introduced by me on January 13th of this year. The stated purpose of this legislation is to amend the District of Columbia Administrative Procedure Act to codify agency deference and clarify that a reviewing court or tribunal shall defer to an agency's reasonable interpretation of a statute or regulation the agency administers, so long as that interpretation is not plainly wrong or inconsistent with the statutory or regulatory language or the council's intent. This legislation is permanent legislation of legislation that's already been adopted on an emergency and temporary basis. In other words, this bill, Bill 26-48, is similar to DC Acts 25-634 and 25-664, which were enacted last fall. The record in this matter will be open for 2 weeks. That is, it will close on Wednesday, April 9th, 2025 at 5 p.m. We have 7 witnesses before we get to the government, a representative from the Office of the Attorney General. I will add that this legislation follows on the heels of a Supreme Court decision in a case that's known as Loper-Bright that reversed decades of precedent with regard to deference by courts to agency interpretations of the law. Let me call witnesses in the order I have them on the list. Fran Swanson, who's Appellate Advocacy Fellow with Legal Aid DC. Come forward, please. Lamont Mabry. Is Lamont Mabry here? Robert Vincent Branham. Dorothy Brazil. Madeline Salomon, who's a legal policy analyst with the Pacific Legal Foundation. That's going to get all 4 seats filled up. Call them as well. I'll call the other 2 witnesses who are virtual, meaning they're participating virtually. I'm not sure they are physically virtual. Ed Hanlon and Cheryl Barnes. The hearing notice said testimony should be limited to 4 minutes. For those who are here in the hearing room, thank you for being here in person. There should be clocks all over the place so you can tell the time. For those who are participating virtually, if you're in gallery view, you'll see the clock or timer at the top of your screen in gallery view. Ms. Swanson, why don't you begin? Turn your microphone on.
There we go. Thank you. Good morning. My name is Fran Swanson, and I'm an attorney at Legal Aid DC's Barbara McBell Appellate Advocacy Project. We are the district's oldest and largest civil legal services organization and serve people living in poverty in the district on a wide range of issues. I would like to start by talking about our work with administrative agencies before explaining why the council should reject, or at a minimum, carefully draft this legislation to ensure that it does not mistakenly expand deference to agencies in trying to simply preserve it. Deference in the district to agencies has never been reflexive. The district courts have always required deference be earned, tied back to, and therefore limited by, the justifications behind deferring to agencies in the first place. Legal aid's work often brings us to the district's administrative agencies, which help govern by drafting regulations and adjudicating disputes. Agency decisions here touch on every aspect of life in the district. We participate in the agency rulemaking process. We also represent people in agency adjudications, which determine whether a family can put food on the table through SNAP or receive unemployment benefits after an unexpected job loss. These adjudications are high stakes and difficult to navigate, especially for people without lawyers. Finally, we seek review of these agency actions in the district courts and ask them to decide, for example, whether an agency has violated the laws that the council has enacted or its own rules. In this way, our courts play a critical role that the council must preserve. The general rule in our legal system is that the courts interpret the laws, attempting to implement the expressed intent of the legislature. This legislation addresses a specific exception to that general rule, circumstances when a court defers to an agency's legal interpretation of a statute that the agency administers. The district courts embrace a version of Chevron deference and carefully developed it here over decades with regards to the district's agencies. They have yet to decide whether to follow the Supreme Court's lead in getting rid of this kind of deference. If passed, this legislation would result in the council stepping in and answering that question. The legislation is intended to codify deference that the district courts have developed, but there's a real risk here that the council upends this careful balance and expands deference in a way that slams the courthouse doors shut to its residents. The most prudent course here would be for the council to allow the courts to develop the law as they deem appropriate. Nothing about the Supreme Court overruling Chevron and eliminating deference to federal agencies interpreting federal laws requires DC courts to do the same or to alter the status quo in any way for our local agencies interpreting our local laws. Indeed, the Supreme Court's decision rested on principles of federal separation of powers and a statute that is inapplicable to us. And while often looking to federal law, the DC Court of Appeals has always charted its own path and developed the law for our unique circumstances. Interrupting this process is unnecessary. Even if the council chooses to step in now, it should do so with more nuance than the law is currently drafted to preserve deference as it currently exists. The council should ensure that it preserves 3 core principles of current case law in any legislation that it passes. First, did the council answer for itself what a term means? Courts look at the text of the statute before looking to the agency's interpretation. That's because the power to make law is the council's. When the statute says what a term means, the courts understand that no other part of the government has the power to give a different answer. The ambiguity must remain as a distinct first step in the deference analysis. As drafted, the law before you substantially eliminates that step. The second core principle is expertise. Courts look at whether the agency offering the interpretation has special expertise in the question at issue. That special expertise is especially troubling here where the mayor is included. Like the Office of Administrative Hearings, the mayor lacks special expertise required for deference. I see that I'm almost out of time. I'll just note that the third core principle here is process. Courts have always looked at the formality and care that an agency has included in its process. When an interpretation is consistent, considered in the result of formal process that followed the agency's rules and the council's, the agency has earned deference. Legal Aid has been in dialogue with the Office of the Attorney General about our concerns. We have proposed 2 broad frameworks here, both of which we are submitting into the record as an attachment to this testimony. We look forward to continuing those conversations with the council and the Office of the Attorney General. Thank you very much for your time. I'd be happy to answer any questions you have.
Thank you, Ms. Swanson. Lamont Mabry, I believe, is not here. Robert Vincent Branham.
Greetings and salutations, Chairman Mendelson. I am Robert Vincent Branham, President Emeritus of the DC Federation of Civic Associations, Chairman Emeritus of the 5th District Citizens Advisory Council, and Chairman Emeritus of the Ward 5 Democrats. I am also a member of the Board of Directors of the DC Open Government Coalition. The views I express are my own. I present myself this morning to offer testimony on Bill 2648, the Review Agency Action Clarification Amendment Act of 2025. The bill will require courts and other tribunals to defer to rulemaking interpretations by the mayor of the District of Columbia or an agency of the district government in an administrative proceeding. For the record, I am not an attorney. However, as a community member, I found the words of this bill to use, quote, plainly wrong, counter to transparency, the advocacy for open government, and may contravene the purpose and principles of freedom of information. Clearly, the effort of this bill is to bar citizens and other challenges to agency rules. It would give agencies clearance to propose rules without fear of community resistance or judicial reversal. This bill, if enacted, would render to Caesar what should be the province of the people. What is more disturbing is the bill Cummings introduced without an essential element as to why it is needed or the specific issues it seeks to address. The bill does not state a problem requiring resolution. What is the problem which the bill seeks to address? It is not often, I quote from President Reagan, former President Reagan, who quipped, "The 9 most terrifying words in the English language are, I am from the government and I'm here to help." Often governments conceal, hide, block, or otherwise propose rules not in the best interest of the district population as a whole, but rather for the benefit of special interest business entities and certain minute vocal political organizations. Public policies such as fiscal policy, transportation, criminal justice, and access to affordable housing, healthcare, and even measures presented by public ballot initiatives would be adversely impacted and restricted from judicial oversight and review. Mr. Chairman, this bill should not and must not pass. And let me follow up on previous testimony. Some years ago, the Department of Employment and Services denied me unemployment compensation. I appealed to the Court of Appeals, DC Court of Appeals, and the Court of Appeals ruled in my favor 3-0. If this bill were enacted, the agency's decision to deny me compensation, I could not have taken to Superior to the court, and that's wrong. And that this bill would not resolve that issue. And on a more personal note to me, I would like to extend my personal request for a speedy recovery to a friend of yours, a friend of mine, Ambrose Lane, who suffered a stroke last week and is recovering, and also to memorialize the work and service of a former colleague, associate, you are now in the council, but here at the council as an employee, Juan Manuel Thompson, who served this council in very honorably. And for that, I thank you.
Thank you, Mr. Branham. Dorothy Brazil.
Good morning. My name is Dorothy Brazil, and for more than 20 years, I have been a civic activist, and I am currently the head of executive director of a civic government organization called DC Watch. I have not come today with prepared testimony, and indeed, I only focused on the legislation last week, but it is not easy to get through, not because of the way it's written, because of what is not there in the bill. Let me state for those who are listening to this hearing what the purpose of this legislation is. This legislation would amend the district's Administrative Procedures Act to add 2 new sections, a C and a D, to section 110. Under the new section, it would state, in reviewing an order or decision of the mayor or an agency in any court or administrative proceeding, the reviewing tribunal shall defer to the mayor or agency's reasonable interpretation of reasonable interpretation of a statute or regulation it administers, provided that the interpretation is not plainly wrong or inconsistent with the statutory or regulatory language or the legislature intent. In other words, this legislation would bar the courthouse door to citizens and civic activists who have long looked to the courts when they are not able to work within the agencies and the departments of the district government to get a resolution of the problem, but more importantly, in many instances, to even get information. Whether or not you're talking about the issue of McMillan Reservoir, the situation at Barry Farms, the question of bicycle lanes on Connecticut Avenue, FOIA requests that go unanswered or linger for years, appeals regarding the zoning and comprehensive plan, or as you recall years ago, where DeLaby and Thurston Rice took the district to court because of the multiple fire code violations threatening the lives of DC students. I would ask that this council, this committee, before it moves forward with this legislation, needs to review the text. And as has always been suggested, probably make some amendments. It is not clear in the legislation what is meant by if an interpretation is plainly wrong or inconsistent. I also would ask this committee to seek written legal opinions from your own legal counsel in the council, as well as from the OAG. My fear is that this legislation, if adopted, will have a history, will be appealable, will be questioned, and will not be understood, because it is a fundamental change from what had been in place before, if adopted. I think it is important for the council, if it wants to be on solid ground, to have some legal document explaining what these two changes mean. Because frankly, I've read it and I'm not clear. I am very pleased to see that a number of attorneys have already weighed in on this. And I ask the council to not move this in 2 weeks or to close the record in 2 weeks, but to itself reach out and get some legal opinion of why is this necessary? What would it change? What would the effect be? And what recourse would civic and citizens groups have as regards taking their cases to the courts or to other tribunals? Thank you.
Thank you, Ms. Brazil. Madeline Salomon.
Chairman Mendelson and members of the committee, my name is Maddie Salomon, Legal Policy Analyst at Pacific Legal Foundation. PLF is a nonprofit public interest law firm dedicated to defending Americans' constitutional rights in courtrooms and capitals around the country. In the last 5 decades, we have brought over 2,400 pro bono legal challenges, including 18 U.S. Supreme Court wins, many of which address the issue that brings us here today. That is proper separation of powers. PLF opposes Bill 26-48, which would force judges to defer to statutory interpretations made by the mayor of DC or a district agency, rather than exercising their duty to interpret the law independently in every single case that comes before them. Judges have an obligation to ensure that all parties are equal before the law and that all arguments are given fair, unbiased consideration. In showing deference to the government's interpretation of a statute, judges abdicate their duty to say what the law is, not what others think that it should be. When judges fail in their duty to interpret the law and render independent, impartial judgments, they are placing a thumb squarely on the scale in favor of the government over its citizens. This bill allows city agencies, and also the mayor in this case, to effectively rewrite laws under the guise of interpretation, grant themselves excessive power, and insulate their decisions from meaningful judicial review. This council should instead incentivize clearer and more precise lawmaking, allowing citizens and businesses to better predict and comply with regulatory requirements. But courts are uniquely equipped and constitutionally required to provide impartial analysis of statutory meaning, free from the conflicts of interest that inherently arise when agencies interpret laws they administer. As the U.S. Supreme Court declared 222 years ago in Marbury v. Madison and cited in last year's Loper-Bright decision, It is emphatically the province and duty of the judicial department to say what the law is. The responsibility of the judiciary to interpret laws is rooted in Article 3 of the Constitution, which assigns to federal judiciary the responsibility and power to adjudicate cases and controversies, concrete disputes with consequences for the parties involved. Lastly, in addition to codifying this unlawful judicial deference, the Amendment Act would create a confusing and ambiguous standard. The two proposed new subsections, 2-510C and D, would require such judicial deference to orders or decisions made and rules adopted by the mayor or an agency, provided that the interpretation is not plainly wrong. The phrase plainly wrong is extremely problematic because it is ambiguous in itself. This phrase is not clearly defined in case law, nor is it defined in the proposed amendment. I urge you and your colleagues to oppose Bill 26-48 as a critical step towards safeguarding individual freedoms, promoting good governance, and upholding the rule of law in the District of Columbia. I appreciate the opportunity to testify, and I'm happy to answer any questions you have. Thanks.
Thank you, Ms. Salomon. Ed Hanlon, who I believe is participating virtually, is he here? Mr. Hanlon?
Chairman Mendelson, can you hear me okay?
You're quiet, but I can hear you.
I don't seem to be able to get my video working.
That's okay. I mean,
All
we'd like
right.
to see you, but that's okay.
Yeah, it won't allow me for some reason. Good morning, Chair Mendelson. My name is Edward Hanlon. I testify today in my personal capacity to oppose your bill, Review of Agency Action Clarification Amendment Act of 2025. This bill carries euphemistic title of clarification, but this bill is not a clarification. That's a profound misnomer. The bill actually is an attempt to gut a Supreme Court holding, which is now binding precedent in every federal court in the country. In doing so, this bill deprives DC residents of a fairer forum for their administrative cases. Under the Mendelson bill, DC residents would actually end up getting a fairer hearing in federal court than in their own DC Court of Appeals. Why shouldn't DC follow the federal standard? In June 2024, the U.S. Supreme Court in Loper Bright overturned Chevron, not clarified it, overturned it. Chevron had required federal courts to defer to agency interpretation of statutes unless an interpretation was arbitrary, capricious, manifestly contrary to the statute. Here, this bill turns the clock backwards and forces a DC court to defer to an agency interpretation of a statute or regulation it administers, provided that interpretation is not plainly wrong. It is not even clear what plainly wrong means. What does plainly wrong mean? Clearly erroneous? Beyond any reasonable doubt, like in a criminal case? An agency's decision has to be so obviously incorrect or unreasonable that no reasonable judge could possibly have reached that same conclusion. This bill wants to take the power away from independent judges and DC courts and put even more power into the hands of agency employees picked by the mayor, confirmed by the council. As Chief Justice Marshall declared in Marbury versus Madison, it is emphatically the province and duty of the judicial department to say what the law is. I believe this bill may ultimately be found to be unconstitutional. The bill unfairly deprives DC courts of their duty to say what the law is. I remind the chairman, two of the justices in Loper Bright, in concurring opinion, said Chevron deference was in fact unconstitutional. This bill grants agency rules and regulations and the bureaucrats who write them a significant advantage over everyday DC citizens and businesses, pushing back against burdensome regulation. This places a thumb on the scale. This places a thumb on the scale of the scale of justice in favor of bureaucrats and over individuals and businesses. Let's think for a moment. The chair of the Zoning Commission, Anthony Hood, has no legal education, never spent a day in law school, has a degree in print shop management, yet this bill says 7 judges of the DC Court of Appeals and all the senior judges of the DC Court of Appeals with over 300 years of cumulative legal experience must defer to Anthony Hood's interpretation of the law. That to me seems rather bizarre. And of course, this bill would give the mayor and the council much greater control over every aspect of our lives. It tilts the balance of power between the 3 branches of government. I would say this is a bill that the president would be proud of. I remind Chairman Mendelson from Justice Thomas's concurring opinion. Chevron deference prevents judges from exercising the independent judgment to resolve ambiguities. By tying a judge's hand, Chevron, this is a quote from Thomas, by tying a judge's hand, Chevron prevents the judiciary from serving as a constitutional check on the executive. It allows the executive to dictate the outcome of cases through erroneous interpretations, end quote. I also would quote Judge Gorsuch, who also said in concurring opinion, and this is not the exact quote. The exact quote is, "We are not bound to respect Chevron, but to inter it." In case I have an accent, I'll translate as, "We are not bound to respect Chevron, but to bury Chevron." So I ask, why are you and the council proposing to dig up what is now a dead body? Thank you.
Thank you, Mr. Hanlon. It would help if you provided us a copy of your statement. You as well, Ms. Brazil.
Oh, here I
Shelburne?
am. After I finish speaking, Chairman Mendelson, now I appear on the screen.
Yes, I see that. If you would provide a copy of your statement. Cheryl Barnes, who's also participating virtually.
Good morning. I'm Cheryl Barnes, Chevy Chase Voice. I'm in very erudite company this morning, and I see that what I've written is, I guess, citizen speak. How can an agency's interpretation be a reasonable interpretation of a statute it administers, and also be plainly wrong or inconsistent with the statutory language or legislature's intent? I don't see can be both. Appending the C and D word salad does not make this a good piece of legislation. It is now more opaque, not more transparent, but perhaps that's the goal. Is this bill designed to immunize the mayor and all agencies from any legal challenges and judicial review? In deciding Chevy Chase zoning case 2325, the Zoning Commission violated zoning regulations. Are you giving it a free pass to do that? Shouldn't you change the zoning regulations rather than change a law that protects taxpayers from abuse and incompetence? Let me put it plainly. Does medium density mean the same thing as moderate density? It does if the Zoning Commission ignores the statutes and says it does. Now with your bill in hand, it does plainly mean the same thing. So that illegal action on the part of the Zoning Commission can't possibly be plainly wrong. And once again, thanks to some fancy legal footwork, there will be no recourse against a wrong agency decision. The Zoning Commission will surely claim that what it did in saying that we can interpret the statute any way we want to is a reasonable showing, but it's not. It doesn't provide a reason. It is an arbitrary decision, willy-nilly, that of a whichever the way wind blows, that of a child king. It is willful. Some might even say it is autocratic. Sarah Barden said that the decision could just as well be rulemaking or contested. So there appears to be an issue with that statute, and that must be addressed. But how will we ever address it after you have closed that file drawer for good? To allow 17th and U a contested hearing, but not Chevy Chase, is arbitrary and has no reason behind the decision, except for Anthony Hood's stated disdain for having to go through a tedious workday. To sum up, I have nothing to add, but to quote Governor Mills from Maine, "We'll see you in court." Thank you.
Thank you, Ms. Barnes. I think I have a couple of questions and a comment. So this is the comment. Several of you who've testified in opposition to this legislation have spoken of how this would be, and I think this is what Dorothy Brazil said, a fundamental change, quote unquote, fundamental change. And several others of you said remarks somewhat similar to that. This bill is meant to preserve the status quo. And so if agency deference, as it's been exercised by the DC Court of Appeals, maybe by the trial courts as well, but probably not. If agency deference has worked over the last 20, 30 years, I'm not quite getting how this legislation, which is intended to preserve that status quo, is a quote fundamental change. Now, I will say that when we moved the emergency and temporary legislation last fall, we were aware that the case law is a lot more nuanced than the language that we've drafted. And so I expect that there will be some changes to the legislative text. But there is no intent behind this to be fundamentally changing what has been the law, as the case law in this jurisdiction for decades. I think I want to say one other thing, and this is more in response to Ms. Salamone. I appreciate your testimony, but there was this one line in your statement: this council should instead incentivize clearer and more precise lawmaking. I completely agree, but as someone who has been drafting legislation either as a member of the council or before that as a staff person, it is impossible in the legislative process to foresee every possible variation of a situation that a law is intended to address. It's just impossible. Sometimes a legislature is sloppy in its drafting. Sometimes the legislature is pretty good in its drafting, but still, in reflection after there's some court challenges, recognizes that the language could have been better. But often it's just there are unforeseen variations of a situation that the law is meant to address. And I think that's the problem for me with Loper Bright, is that a piece of that, as I understand it, was the court saying, well, legislatures should just be clear. I just admitted sometimes they could be clearer, but I'm also saying that it's impossible to be clear all the time. Since I brought you up, maybe you want to respond.
Yeah, I'd like to respond to a number of the things that you said. First of all, I empathize with the fact that it is difficult drafting legislation. But that doesn't mean that the drafter should be rewarded for imprecise language by having the court just automatically defer to their retroactive amendment of legislation. Citizens need to be able to read a law and understand what it is and how it applies to them. If the courts are to defer to an agency coming in later and saying, well, we meant this, but the law doesn't actually say that, then that's an injustice to citizens. And courts serve in that role all the time. Case law evolves over time due to imprecision in drafting. And it's incumbent upon the legislature to go back and clarify based on case law if their rules are not being interpreted the way that they perhaps intended. I'd also like to address a premise that you kind of started the comments with, which is that the precedent that existed under Chevron was working before. That precedent was heavily criticized. It really did allow agencies to exert a tremendous power over citizens, and it wasn't working. It's why it was just ruled unconstitutional. If this circuit decides to bring back a precedent that was ruled unconstitutional, it would be a disservice to the citizens in this district. And so I guess even in contract law, when ruling about ambiguity in a contract, the courts don't favor the person who drafted it, who maybe wrote something that they didn't intend and later on regret that decision. That would in effect be what we would be doing here. And that was what was happening under Chevron, is allowing agencies to relook at their legislation they didn't draft well, and in some cases make it into what they wanted to, because these agencies are acting as political parties in those situations. And sometimes they're really trying to steer their rules in a way that serves them best. And there's lots of case law that does exactly that. Loper Bright was one of those, where citizens were being penalized because the government didn't have enough money in their budget to pay for people to oversee fishermen. And so they were then forcing citizens to fund that, and saying that that was what their rule said the entire time, which it absolutely wasn't. And that's just one example.
Mr. Chairman, if I may add another perspective, a comment. You stated that this bill simply maintains the status quo.
The intent behind the bill
The
is to
intent is to
maintain
maintain the status quo. But the status quo is an emergency legislation that the people of the District of Columbia didn't have an opportunity.
No. I did not mean status quo as in the emergency bills. The status quo as in the case law in the district for the last 20, 30 years, however many decades.
Yes, which was, as the legal minds on this panel have indicated, was overturned. So I just want to say
Actually,
that
it's not been overturned.
the status quo is currently the bill that was enacted by the council on an emergency basis that was not given, that the people of the district were not given an opportunity to comment on, because the public comment is not taken on emergency bills. It just comes before the council and the council moves on it on an emergency
I'm a
basis.
little bit confused, and forgive me for cutting you off. The case law in the District of Columbia has followed the federal precedent for decades. The Supreme Court's decision deals with federal law, federal cases, federal courts, federal agencies. However, there is a lot of similarity between how we as a government operate in the District of Columbia and how the federal government operates. So there is concern with the Loper Bright decision that the DC courts will follow suit. They have not yet. So when I say maintain the status quo, I'm not talking about the status quo with the emergency bill we passed. I'm talking about the status quo with regard to judicial interpretation, with how to apply agency rules or statutes that has been, the case law has been the law in the district for decades. That's what I mean by status quo. And I get what you're saying about, well, there was not public comment when we adopted the legislation last fall. That's why we're having the hearing today. The legislation we adopted last fall is temporary in nature. If it's to be permanent, we have this hearing.
Part of the problem is that it doesn't actually codify Chevron. It actually does something different. And that's why a number of us have pointed out the plainly wrong phrase in this piece of legislation. And I believe there was another submission that kind of delved into the case law specifically about what what Chevron, the two-part test that Chevron actually followed. And this piece of legislation does something different fundamentally. So it actually is not codifying existing precedent that again was ruled unconstitutional. This does something different.
Well, I already indicated that I think that the language needs some refinement, and that was clear to us when we did the emergency legislation last fall.
Mr. Chairman, could I just add one thing? In your remarks, you indicated the imprecision in legislative language. I can't think of a more telling example than this current bill, where it has all sorts of terms that are supposed to be applied. Reasonable interpretation, plainly wrong, inconsistent. There is nowhere in either the Administrative Procedures Act or in the legislation that defines what those terms are. So if your effort is to move forward with something to clarify something, I think it adds more doubt and inconsistency. And as has been already stated, this was moved in November as emergency legislation that did not allow for public vetting, public comments. Now you have an opportunity to do just that. I urge you not only to do just that, but as you have said, the Loper decision just was made last year in June. There are a myriad of legal opinions, Harvard Law School analyses of what the meaning of Chevron was, what the meaning of Loper was. I have tried to myself read some of these treatises, and I'm having difficulty. I doubt that your own legal counsel has looked at it. I would ask you to not move forward with submissions of testimony in 2 weeks, to allow your staff, the Office of the Attorney General, the Office of the Counsel's Legal Counsel, to in fact look at Loper, look at Chevron, look at cases and decisions that have been made or written about since then, because it's not a black and white situation. And if you could share with us, is there some immediate need to move this legislation now? I'd appreciate it, because I've come up empty. I've called the Office of the Attorney General, no response, which is typical.
I'm going to interrupt. Ms. Swanson, you look like you want to say something, but I do have some questions for you. I'll get to you in a second.
Of course. Yes, if it would be helpful, I know you expressed an interest in potentially refining the language to capture case law as it exists. I'd be happy to talk through a couple of areas that legal aid sees for improvement, but maybe it would be helpful for me to answer your specific questions first.
I should go to you, but I'm still tempted to. So I'll come to you in a minute.
Of course.
That's okay. So in front of me are, I'm going to say 3 different arguments. Legal aid, which is saying we don't have this quite right. Mr. Branham and Ms. Brazil and Ms. Barnes, and actually Mr. Hanlon, who are all saying, well, this is a fundamental change. And this is outrageous because it's a fundamental change. And then Ms. Salomon, who I'm kind of assuming that your organization was involved with the Supreme Court litigation, maybe not directly, but has been very much involved with this issue for a number of years. I'm aware that there's been a lot of criticism of the Chevron precedent for decades, seems to be mostly from conservative quarters. And I kind of want to speak to that for a minute, a little bit of exchange. I'm not sure we're going to agree, but I think as I see it, the issue for, and I'll say conservatives, I don't want to be putting a label on you. I'm not sure the Pacific Legal Foundation, but my sense of it is that conservatives have resented for years federal agencies that have done rulemaking. They're not elected. For sure, the President of the United States is not individually looking at each word of each rulemaking. So it, in that sense, is sort of disconnected from the president, and it ends and has the effect of interpreting, arguably reinterpreting statutes that have been adopted by Congress. To me, the solution, well, it would be nice if Congress wrote its laws more precisely, but I already spoke to that. Sometimes legislatures are sloppy, hard to defend that. Nonetheless, that's the law, it has to be interpreted. Sometimes there's a lot of variation in what the effect is that can't be foreseen by a legislature. So it's impossible to get to that state of nirvana with regard to legislative drafting. But what I see has come of this with the Loper Bright is it actually is encouraging judicial activism. So instead of an agency that we may resent because it's interpreting a law in ways that we don't agree, but does have some expertise, now it's going to be a court which doesn't have that expertise. It just doesn't. Whatever expertise it has would have through witnesses. If we're on the appellate level, then it's not witnesses, it would be the record. So it's somewhat disconnected or attenuated. So there's now a freer reign for the courts, which on the federal level and in the district, not many states, is also not elected. And they're going to apply their expertise with regard to the substance of an issue that's before them where there's a legal disagreement. I don't see that as a better approach. I do see that as shifting some authority from the executive branch, but shifting it to where? Shifting it to the judicial branch in the name of legislatures should draft better, which they're never going to do.
I guess to address, first of all, PLF is a nonpartisan organization. We're not conservative, we're not liberal.
Well, everybody is conservative or liberal or moderate, but I'm sorry, everybody is, but go on.
Well, as an organization, we are nonpartisan. As to your point about judges not being experts, no, they're not expected to be experts in every single area of the law, which is why they allow parties to present their expert testimony, which the government would have their opportunity to do in every case, and the opposing party would have their opportunity to do. What this legislation does and has done since Chevron is to say, well, we're not going to even consider really the other side's legal argument about what the law says. We're only going to consider what the government wants it to be. And that inherently, an agency is a political animal. I think you started with the premise that they aren't. They absolutely are. I think there's been a debate around the country of late about that specific issue where it's very clear that when the administration shifts, those in power within an agency also do, which makes them, in many respects, part of the executive branch. And so why would we give an arm of the government more power over its citizens in a court where a judge is supposed to act impartially? I will acknowledge that the court system doesn't always act perfectly. As an attorney, I don't always agree with how a judge has ruled in a case that I've been a part of. But that doesn't mean that we just put the thumb on the scale on the side of the government, which is what this would do. We need to empower judges to be able to weigh evidence, to weigh expert testimony, and to look objectively at what the law says and what it does not say, not read in what we wish it said. That's a very dangerous precedent, and it does allow retroactive reinterpretation, and it's unfair to individuals being impacted by those laws. Sometimes they face heavy monetary penalties. It's a terrible precedent, and I really urge you not to kind of revamp this precedent that has not served citizens well for a very long time on either side of the aisle.
I'm going to leave it there and turn to Ms. Swanson. Thank you, though. I had a threshold question for you, Ms. Swanson.
Mr. Chairman.
You don't oppose
Chairman,
deference. It's just how this is drafted.
Legal Aid does not think that this legislation is required because the Loper Bright decision, as you explained, did not affect deference to district agencies interpreting district statutes. And so as a threshold matter, we think that the DC Court of Appeals should be able to answer this question just as it does any other legal question, and the council could always afterwards enact legislation if it disagrees with that. But we understand that the council maybe disagrees and thinks that it is necessary to act. And so we want to make sure that if the council is doing that. It's actually using legislation that preserves deference as it exists. At Legal Aid, we see the administrative process when it works really well, when it's open rather than captured, when there's opportunity for dialogue and something like, rulemaking notice and comment. But as I described in my testimony, we also see it when it fails the district's residents. And so it's important to us that the balance that the DC Courts of Appeals have struck is actually preserved in the legislation if the council moves forward with it. We're really sympathetic to the fact that it's hard to draft legislation that captures all of the nuances that the DC Court of Appeals has developed over the course of 40 years. And so what we started with when we were drafting proposed alternative legislation, which I've included here in my testimony, is, what is it that the DC Court of Appeals is doing when it's doing the deference inquiry? And at bottom, the DC Court of Appeals is asking, has the agency earned deference here? Because deference is never reflexive, it's not automatic. We know that the default rule is that the courts say what the law is. So if the court is going to deviate from that, special conditions have to exist. And that's how we've gone about drafting this proposed legislation to capture deference as it exists. A big part of that is actually expertise, which you were talking about earlier. There are certainly situations in which agencies are more expert than courts. So thinking, for example, of a statute that says this chemical has to be maintained at safe levels. Well, if there's an agency that administers the statute, that has a team of scientists who has been working on this question for a decade, that agency would be better positioned to answer the question of what safe means as compared to the Court of Appeals. And so the court would decide in that instance that the agency has earned deference through its expertise. But that's very different than something like the term fair notice, which the council might include in a statute that it enacts. For example, that somebody needs to have fair notice before their benefits are terminated. An agency is not more expert than a court in determining what the terms fair notice mean. So we agree that expertise is a really important consideration, and that's why it's essential that the legislation reflect that. I'd be happy to talk about our two other main concerns, unless you have other questions.
I do, but I appreciate what you said. The example of this, a chemical stored at a safe level.
Yes.
We also want consistency. So if the agency reasonably defines what a safe level is, we want consistency from case to case to case if there are multiple court cases, as opposed to, this gets back to what I said earlier about judicial activism, this judge saying, well, such and such is safe, and a different judge saying a different level is safe. But I do want to pick on this. So why should we assume that the Loper-Bright ruling won't impact the Court of Appeals deference to district agencies under the district's APA? In one opinion issued after Loper-Bright, the Court of Appeals stated, quote, "We reserve judgment on any potential impact of Loper-Bright enterprises on our well-established deference to an agency's interpretation of a relevant statute or regulations." In another case, I should say unquote, in another case involving a dispute over the exemption of single-family home sales from TOPA, that's the Tenant Opportunity to Purchase Act, the court issued an opinion which states, quote, "For the sake of this petition for review, we will assume that we owe no deference to the Department of Housing's interpretation of the act," unquote, and cites the Loper-Bright decision as creating, quote, "uncertainty about the propriety, unquote, of deference to the department's legal analysis." So the court's already twice made reference to Loper-Bright in different ways, one saying we owe no deference, and the other saying we're going to put aside Loper-Bright for the moment.
Yes, so I think the Court of Appeals has rightly acknowledged that Loper-Bright could change the law in the district. And, the DC Court of Appeals, I think, because we do things a little bit differently, but it's often influenced by federal law, will acknowledge if there's a significant Supreme Court decision, but they haven't decided that question. And there are plenty of reasons to think that they won't decide the question in favor of Loper-Bright. So, for example, a big justification behind Loper-Bright was the constitutional separation of powers. You heard quotations earlier from Marbury v. Madison. That's addressing the Article 3 judiciary, but we don't have an Article 3 system here in the District of Columbia. And so there's a little bit more permeability when it comes to the separation of powers.
Yes, but our form of government under the Home Rule Act is modeled after the federal
Right.
system. And so we see over and over again where the Court of Appeals will look to federal practice for guidance.
Certainly. And so I don't want to suggest that it's absolutely certain that the DC Court of Appeals would look at Loper-Bright and say that has no place here. I think that would be inaccurate, and none of us can predict what they'll do. If I could point to just one other difference, and then I'd love to speak more about the consistency point that you raised, because I think it's a hugely important one when we're looking at deference in this legislation. So the one difference that I would note is that the Supreme Court in Loper-Bright also said on stare decisis grounds, that is the precedent that's come before, we, the Supreme Court, have basically been ignoring Chevron for years, and we just haven't been implementing this two-part test. And so that's not something that should constrain us from changing things now. Here in the district, Chevron deference is alive and well, and the DC Court of Appeals has continued to cite it, even as the Supreme Court diverged from it and essentially killed the doctrine before Loper-Bright. But I realize that the council might have reasons for just wanting to answer the question now. So if I could just talk about your consistency concern. The thinking there would be, if the expert agency has said this is what the safe level is, the court would defer to it. Courts care a lot about consistency when it comes to deference. And that's why in asking whether the agency has earned deference, they look at the process and the formality that the agency has used at arriving at its interpretation. So to give an example, oftentimes when an agency action is challenged, an agency will take a position in the brief that it submits to the court that says, this is our legal interpretation of what this statute means. Courts treat that post hoc justification, which might be inconsistent with earlier interpretations, very differently than an agency interpretation that is the result of a formal process like notice and comment rulemaking. And so it's really important that in capturing deference as it exists in the district, the legislation as drafted capture the court's concern for consistency. And I already spoke about our first concern with the sort of first step, a court asking, has the statute answered the question of what the term means, or is the statute ambiguous? And we understand the intention behind the legislation to preserve that, but we think as drafted, it doesn't do that.
Give me a second. So I appreciate everyone's testimony. A couple of people did not submit statements, which would be helpful. We are not going to move to mark up this bill in the next 2 weeks or 3 weeks, probably not until after we're done with the budget. Maybe I shouldn't say that, but we're not going to move to mark it up super quickly. I'm thinking of the comment about the record. We have to have a deadline for closing the record because we file the record. That does not mean that the council does not continue to consider input. It's just that input that comes in after the record closes probably will not be included in the record. And the record is just that. Separately, when we move legislation, there's a committee report. Ms. Brazil, you should know all this. And the committee report often will attach to it testimony, but also maybe letters and items that come in after the record closes. But we do have to have a deadline for closing the record. As I indicated at the beginning, or at some point, maybe a couple of times, I don't defend the legislation as introduced to be written as well as we want it to be to cover some nuances. Nuances may be the wrong word, but I think you know what I mean. And so there's going to be more effort at improving the language. Just want to make that clear. Ms. Brazil, you so look like you want to say something.
Mr. Chairman, please tell me if this is inappropriate, but you could go a long way in helping citizens and civic groups understand the legislation. If you could share with us, where did the emergency legislation, where did this even draft come from? And I understand there has been some consultation and discussion involving the executive office of the mayor, the office of the attorney general, and your office. The element that has been not in the loop is consultation with the community, civic leaders, and what have you. So can you share with us, where did the draft of the emergency legislation back in November come from? And where did this draft come from?
Well, I think you know, because you just said, we did the emergency and temporary in the fall when we were approached by both the executive and the attorney general and our own general counsel's office. That's where it came from.
Mr. Chairman.
And let me add as well, because this is slightly annoying. We're having a public hearing today. We cannot change the law on a permanent basis without having a public hearing, which, if I remember correctly, is an opportunity for public comment.
Mr. Chairman, can I
I
comment?
appreciate that, but Mr. Chairman, I think it would be beneficial if, in terms of the record, you could get somebody from the executive office of the mayor, one of her attorneys. I see that somewhere down on the witness list, the office of the attorney general, the solicitor general is testifying. So that this can objectively be discussed. Is there a real alarm, a real concern, or have there been cases that are coming down the pike that the executive office of the mayor and the attorney general is concerned about? Or is this sort of, well, LOPR was adopted last year, we need to get ahead of LOPR and do something or what have you? I mean, again, in terms of, I think this is one of those important issues where all the cards need to be on the table. Citizens need to know what has been
Let me, I think this, I answer your question and I don't think you hear me.
I hear you.
There was a considerable concern. I don't think it's wrong to say that there was a lot of reaction around the country when the Supreme Court issued its Loper Bright decision and some controversy around it. Last fall, the executive, the attorney general, our general counsel approached me with regard to this issue. There is a feeling, and I'm kind of at this responding to Ms. Swanson on this, there was a feeling that we should get ahead of the issue rather than be reflexive. And so that's why this is before us. And today is a public hearing, and there's a record that will be open for 2 weeks. The notice was issued maybe a month ago, but the legislation is not going to move in the next 2 weeks or 3 weeks. And so there's ample opportunity for public comment on this, but I want to repeat, because I think this has been misunderstood, the intent behind the legislation is to preserve the status quo with regard to the case law in the District of Columbia. Whether
Mr. Chairman, may I
the
speak?
language of this bill does that, I concede that the language may need some refinement, but that's the intent. Yes, Mr. Hanlon, then we're going to move on.
Oh, thank you. I had my hand up for a while. I'm sorry if I shouted. I wanted to
No,
be.
but it's always better to be in person, but please proceed.
Mr. Chairman, I have a fundamental question here. I don't understand why. You haven't explained why this bill is better for the people of the District of Columbia than Loper Bright. here, these agency people, you appoint them, the mayor appoints them, you confirm them every 3 or 4 years, they're beholden to you. And a poor citizen facing one of these administrative tribunals will not be able to go to court, to have the court look at this matter unless they can show the decision was plainly wrong. And you haven't explained to us why that is better and why it is better for DC to act differently than every federal court in the country and why we shouldn't follow federal precedent. I mean, the Supreme Court was really clear. The majority of the Supreme Court was really clear that Chevron was wrongly decided. So why is it better that we follow Chevron and not Loper Bright? Why is it better for the citizens? That's what I don't understand about it.
Well, I don't think you were listening to some of the exchange here, but I don't think I'm going to go back over that again because I've already spoken to that.
I mean,
Among other
consistency.
things, I use such words as consistency. I use such words as judicial activism. You may disagree with me, but I think that if you play the tape and you will see that I did speak to that.
Well, consistency, but a poor human being going into trying to appeal the administrative decision has this enormous burden on their shoulders of having to show that it was plainly wrong. And I don't understand why that's better for the citizens.
You may
of the
argue that,
democracy.
I mean, that's been the practice for the last several decades. And you may argue that that's the wrong practice, but, and when I was an ANC commissioner, I took the BZA and the zoning commission and sometimes even the ABC board, maybe the mayor, I can't quite remember, to court many, many times, one from time to time. So I kind of understand this.
Mm.
Thank you all for your testimony. Those of you who did not give me a written statement, please do so. I really do appreciate it. I think this has been helpful to us. So thank you. I'm going to turn now to the executive, Caroline Van Zyl, the Solicitor General, Office of the Attorney General. So I guess, Ms. Van Zyl, we've been keeping you busy.
It is good to see you again, Chairman Mendelson.
Thank you. Likewise.
Chairman Mendelson and members of the Committee of the Whole, good morning. My name is Caroline Van Zyl. I am the Solicitor General for the Office of the Attorney General for the District of Columbia. I appreciate the opportunity to testify in support of Bill 2648, Review of Agency Action Clarification Amendment Act of 2025. This bill would codify longstanding principles of administrative deference by instructing courts and other tribunals reviewing agency action to defer to the mayor or agency's reasonable interpretation of a statute or regulation it administers, provided that the interpretation is not plainly wrong or inconsistent with the statutory or regulatory language or the legislature's intent. Courts in the district have long applied that standard when reviewing agency decisions, and this bill would maintain the status quo by incorporating that standard of review into the District of Columbia Administrative Procedure Act, or DCAPA. Administrative deference is an important tool that allows agencies to implement the council's legislative priorities and protect district residents. This bill would express the council's intent that under the DCAPA, the same principles that courts have applied for decades should continue to govern local cases. Since the New Deal, federal and district courts reviewing agency action have given deference to an agency's reasonable interpretation of an ambiguous statute that the agency administers.
This means that even if the agency's reading is not the only permissible reading, the court will uphold it so long as it is reasonable. This gives agencies a measure of flexibility to make legislation workable in practice. For example, in one DC Court of Appeals case, a landlord violated and then challenged the Rental Housing Commission's requirements for adjusting a rent ceiling. The court held that the commission's reading of the requirements was reasonable, upheld its actions, and ordered the landlord to refund the overcharged rent to his tenant. Although it is impossible to quantify exactly how many cases like that one exist where the court has upheld an agency's reasonable interpretation of a statute, we estimate the deference standards have been applied in nearly 1,000 other decisions in the district over the past century, in cases involving taxation, public safety, and public benefits alike. Last year, in a closely divided case called Loper-Bright, the Supreme Court overturned precedent that governed deference under the Federal Administrative Procedure Act, which was often called Chevron deference. Among other things, the majority pointed to the federal APA's provision empowering courts to, quote, decide all relevant questions of law, end quote, as incompatible with giving deference to interpretations reached by administrative agencies. The dissenting justices, led by Justice Kagan, warned that the Loper-Bright opinion could have a negative impact on the provision of public services. Because the DC APA contains similar language to the federal APA, the DC Court of Appeals has expressed interest in the question of whether Loper-Bright should also apply in the district under the DC APA. Put simply, applying the Loper-Bright decision to our local administrative system would be disruptive and could be bad for the district and its residents. The DC Court of Appeals has long applied a rule that is similar to the federal Chevron rule, deferring to reasonable agency interpretations of ambiguous statutes, but not deferring if the agency's reading is unreasonable. At the same time, our court has often deployed a more flexible variation of the federal approach in our municipal context. For instance, the DC Court of Appeals acknowledges that the deference owed to an agency depends on a number of factors, including whether the position is longstanding or has frequently changed, the thoroughness of the agency's reasoning, and how much the agency's subject matter expertise plays a part in the interpretation. This bill addresses the judicial landscape in the district by codifying 3 important principles. First, it reaffirms the importance of administrative deference in our local law. Second, it eliminates any confusion that has arisen since Loper-Bright. And third, it preserves the status quo, taking each in turn. First, deference is an important tool for promoting stability in the law and fostering workable government. The council routinely passes laws that are written to give agencies flexibility in implementing the statutory scheme, and residents and businesses rely on agency interpretations to order their affairs. To provide just one example, the district's firearm registration statute requires the Metropolitan Police Department to deny a firearm registration to anyone with a prior felony conviction. MPD has written regulations explaining how it will evaluate conviction records from other jurisdictions to determine if they're disqualifying, which allows residents to know in advance whether they are permitted to own a firearm in the district. Eliminating deference could call these regulations and others into doubt. Additionally, empirical research also shows that deference makes judicial decisions more predictable and less partisan. Second, this bill will eliminate any confusion that has arisen since Loper-Bright. Although we believe that district law remains as it ever was and that Loper-Bright does not govern the DC APA, our agencies and the public deserve certainty. The bill's language directly mirrors recent decisions of the DC Court of Appeals, codifying the status quo. To be clear, that standard is not a mere rubber stamp. Under the current case law, agencies lose about as often as they win, but that standard is tried and true and has proved workable for agencies and litigants alike. Third, this bill maintains the status quo by carefully codifying a deference rule that captures the nuances of current district law. That is why the bill, for example, uses the plainly wrong standard adopted by district courts, rather than the multi-step procedure used by federal courts prior to Loper-Bright. Although those standards are similar, the plainly wrong language has been applied by the DC Court of Appeals in dozens of cases, forming a detailed body of administrative law unique to the district. Likewise, that is why the bill also codifies a deference rule for agency interpretations of their own regulations. In the district, deference applies the same way to interpretations of statutes and regulations, which is not necessarily true for federal courts. By using the language that the DC Court of Appeals itself has long employed, this bill should make clear that it is preserving, not changing, the status quo. It is important to reiterate that nothing in this bill upsets existing decisions explaining when deference is inappropriate, such as when an agency did not actually interpret a statute or regulation that it administers, when an agency's interpretation has frequently changed without explanation, or when an agency acts unlawfully by failing to follow required procedures. The bill maintains these limitations and does not attempt to change them. The purpose of this bill is not to enhance the government's regulatory authority, but rather to benefit district residents. In the district, administrative agencies create rules and interpret statutes to protect residents and businesses alike, ensuring a level playing field. Reaffirming longstanding deference principles will only further the public interest. For all these reasons, the Office of the Attorney General recommends that the Council enact this bill. Given the importance of the bill to the district, we are also open to continuing to work with other stakeholders and the Council to find common language. I would be pleased to answer any questions.
Thank you, Ms. Van Zyl. I was struck by the previous witnesses. There was a comment by one of them that the Supreme Court had essentially abandoned Chevron over the years through various subsequent interpretations. How do you see that?
So that was part of the logic of Loper-Bright when it came to whether stare decisis should weigh heavily in favor of keeping Chevron deference. I think you got it exactly right, that while the United States Supreme Court had silently edged away from deference over the last several years, our courts have not done that. Our courts rely on deference all the time. As you noted in the colloquy with some of the earlier witnesses, in two recent opinions, our court has raised the issue of whether Loper-Bright applies here in the district or not, because those cases involved deference. So that may be true in the context of the US Supreme Court, that they had edged away from Chevron a bit. But I would highlight that I think you're exactly correct, that our local Court of Appeals, the DC Court of Appeals, has continued to apply deference in the same way that it ever did.
Witnesses such as Legal Aid have suggested that this bill be amended so that courts adhere to the two-part test enunciated in Chevron. Do our courts use this two-part test when assessing the validity of district agencies' interpretation of a statute?
So our courts do not consistently or rigidly use that two-part framework. You will find it in some of the case law. But honestly, we think that the concerns voiced by Legal Aid are actually already resolved by the bill's current text. So the current text of the bill uses the phrase reasonable interpretation. It says deference is not warranted if the interpretation is plainly wrong or inconsistent with the statutory or regulatory language or the legislature's intent. That standard, I think, makes clear that some ambiguity is necessary for deference to apply. So just to spell that out a little bit, in our view, an interpretation of a statute can't be reasonable unless it's either plainly correct, in which case no deference is needed, or it's reasonably filling a gap or resolving an ambiguity in the statute. So if the statute is clear and the agency's interpretation is wrong, under this bill, the agency doesn't get deference. So in essence, what it does is it collapses the two-step framework into one more flexible test. And that phrasing is used in the bill is more similar to the DC Court of Appeals existing cases, which, as I mentioned, only rarely invoke that formal two-step framework. Now, I will add that while we don't think that it's absolutely necessary to add additional language, if there's real concern that the bill is currently phrased does not correctly capture the status quo, we would be fine inserting clarifying language into the draft to make clear that deference only applies when a statute or regulation is silent or ambiguous on a particular issue. So we don't think it's necessary, but we're open to a change if the change is based on language that's in existing DC Court of Appeals cases.
Do you have any concern that the court will read the legislation as a change to the status quo?
No, we don't.
Why not?
The language is taken directly from DC Court of Appeals cases, and given that the court has applied these standards without difficulty for decades, we don't have significant concern that the court will misread the language as a change to the status quo. Now, in any event, the council, I think, made fairly clear in the resolution accompanying the emergency version of the bill that the goal was to preserve the status quo. The council could emphasize that goal again if it sees fit in any report on the legislation. As you know, the DC Court of Appeals places significant weight on legislative history, so it will likely pay careful attention in any future cases to statements that this body makes. So I think the combination of the direct quotation from the DC Court of Appeals language and I would imagine the accompanying legislative history will make very clear the intent of this law.
I'm a little concerned with the plainly wrong language phrase, because I think it could be read as, well, the mayor or agency needs to be reasonable. However, that's qualified by, but the interpretation is not plainly wrong. So if it's not plainly wrong, it's just wrong. Or preponderantly, this is a made-up word, preponderantly wrong, then it would be okay even if it's not reasonable. I'm not sure I quite said that right, but it seems like a qualification. Why not just simply say, shall defer to the mayor's reasonable interpretation, provided that that's not inconsistent with the legislature's intent?
Well, so a few responses to that, Chairman. I think, so the first phrase in the statute as you read it is that the tribunal shall defer to a mayor agency's reasonable interpretation. That's kind of front and center, primary, the first language, the first standard that you confront.
Sure,
So-
but then qualified, that's, the meaning of that is qualified by the proviso.
Well, I think provided that is sort of an exception, I think it raises the bar rather than modifying the bar, right? So you defer if it's reasonable, provided that in addition, it is not plainly wrong or inconsistent with the statutory or regulatory language or the legislature's intent. So if you flunk any of those three tests, you don't get deference. If you flunk the reasonable test, you don't get deference. So in other words, as I read it, these are sort of independent hurdles that any agency interpretation would have to surmount. And importantly, I would just emphasize that the reason why plainly wrong is in here is because it is perhaps the most common formulation of deference in the DC Court of Appeals cases. This same language is in dozens of cases. It hasn't led to any confusion. It has become essentially a term of art. And my concern would be that if the council were to eliminate that language, that a court might infer that the intent was to modify DC Court of Appeals precedent by eliminating one of the most common formulations of deference in our case law. So for that reason, I think it actually might be quite important to preserve that language, which again just reiterates what is found in dozens of DC Court of Appeals cases over several decades.
You sort of touched on this, but I'm going to ask it front and center. You heard testimony from legal aid suggesting this legislation is unnecessary. How would you respond to that assertion? Without clarifying the legislation, what would be the effect of the Loper-Bright decision in the district? So you sort of touched on that, but I think I want you to address that more, confront that, that this legislation is unnecessary. Well, we could wait until the court adopts the Loper-Bright principle.
Well, look, there's some points on which I agree with my friend Ms. Swanson, but I disagree on the fundamental point that we can just wait and see what happens with Loper-Bright. So let me spell that out in terms of both the agreement and the disagreement. So I agree that right now, Loper-Bright is not the law of the district. As a technical matter, it only applies to decisions under the Federal Administrative Procedure Act. With that said, the language in the federal APA is nearly identical to the relevant language in the DC APA. And because of this textual similarity and perhaps because of the fact that Congress drafted both the federal APA and the DC APA, the DC Court of Appeals had decided sua sponte, so of its own accord, to go en banc as a full appellate court, something that it rarely does, to consider whether the Loper-Bright decision required reconsideration of its deference precedents. Now, that appeal was later dismissed, but as you noted, again, in at least 2 published decisions since then, the courts expressed some concern that its precedents may be affected by the Loper-Bright decision. And if the DC Court of Appeals did adopt Loper-Bright, it would be incredibly disruptive to the district. Citizens and businesses could no longer rely on an agency's regulatory opinion about a statute's meaning, no matter how formal that opinion was, no matter how thorough, no matter how long-standing. It would just be up to the court de novo to decide what the law meant. And until the question was litigated before court, it would be unsettled. Even a small interim period of deference not applying in the district could result in a new wave of litigation, challenging even long-standing and reasonable agency interpretations of statutes. And what's more, in that interim period, agencies would then need to go to the council seeking emergency retroactive legislation to resolve ambiguities in statutes rather than just being able to adopt reasonable interpretations themselves. And in our view, that would create extra work with little upside. And I will say, you know, the DC Court of Appeals doesn't issue many published decisions. It resolves most cases in an unpublished posture. So the fact that we've already seen 2 cases raising this question, as well as an attempt at taking it en banc, I can tell you the plurality of our cases are administrative law cases that my office handles. There's a high volume of cases in this space. It strikes me as extremely unlikely that this issue won't need to be resolved one way or the other. And so the question is just, is it better for the council to clarify its intent or to sit back and leave it to the courts? And I think when it comes to the meaning of local district law, the council is the appropriate actor to kind of resolve that ambiguity.
And I would add proactively rather than reactively.
Yes.
Give me just a second. I don't have any other questions. So just to be clear, I'm not saying the committee will wait until after the budget because I consider this important and I don't remember the timing of the emergency and the temporary. We're going to look at the language and I mean, I moved the emergency and temporary, so I'm not walking away from this issue. We will look at the language and in light of the comments that we've received. to be more confident that the language that we have in this legislation more accurately reflects, no, I will say, look at the language to be sure that it accurately reflects all the nuances that are in the case law. And so we're open to suggestions from anybody and everybody with regard to how to improve the language and then move forward. And I think that kind of covers all the points I want to make. Thank you for your testimony. And again, to the witnesses who testified earlier, thank you for your testimony. The record in this matter is open until 5 o'clock on Wednesday, April 9th, 2025. And just to be clear to some folks, that does not mean that after April 9th that we close the door and close the windows and no longer answer the phone. No, of course, we will consider any comments and input, but we're required to file a record. And that record will be what we have as of 5 p.m. Wednesday, April 9th. The time is 11:32 a.m. and this hearing is adjourned.